Hello, Mr. Colvin. What can I do for you?
Let's cut to the chase. My good friend and client, Bakke, feels like he's being treated unfairly and illegally.
Why does he feel that way?
Although he has extremely high scores, my client has been rejected twice because of the university's so-called quota for minorities.
Mr. Colvin, you really seem like a good kid. Unfortunately, that's how the system works.
That's how it's going to be. We'll let the courts decide.
Then I encourage you to do so.
We are reunited at the Supreme Court to resolve the confusion of affirmative action dealing with the case 438 U.S. 265 California versus Bakke.
I would like to call Mr. Bakke to the stand. Mr. Bakke, where are you here today?
I'm here to stand for equality. When I got rejected twice to UC Davis, I realized that there must be something going on considering my extreme credentials.
And what were they doing wrong?
They were using a quota system where 16 out of 100 applicants were automatically being reserved for the minority.
So that means what to you?
That means the university is not giving equal treatment to all of its applicants.
So in layman's terms, although my client has outstanding credentials, he's being limited to opportunities based on a special program in which majorities cannot take part. The defense rests.
So you don't think that it's fair to give minorities a chance to get a better life, even though they're at a disadvantage?
It is not fair, sir. It is not fair. You can't just say that they're disadvantaged based on a racial basis. There are also people from the majority that are disadvantaged.
Affirmative action clearly encourages the integration of races, sir.
Well, I believe that my credentials speak for themselves. My academic achievements should be the one taken into consideration when I'm applying for this position, not the color of my skin.
As you see, my client, the University of California appealed this case because they believe that the Court of California, along with Mr. Bakke, violated the Civil Rights Act of 1964, which allows affirmative action to take place. Your Honor, standing for the less fortunate is not a crime. Please don't make it one.
We can twist things up and make them appear as fair, Your Honor, but justice is justice. Taking away my client's right to the 14th Amendment Equal Protection Clause cannot be forgotten. Furthermore, when coming from an educational institution, think about what message we're sending to all Americans. Justice needs to rise. After all the hard work my client did to obtain his excellent credentials, he should not be denied higher education on the basis of his skin color.
The decision of this case will define whether minorities actually have a chance, Your Honor. I have seen many unfortunate, poor, and uneducated people from the minorities that struggle enormously in life. Let them have a chance. As I stand with the university, they did what they were supposed to, apply affirmative action in order to let them have a future.
The lower courts have agreed with Mr. Bakke, because the law also does. Equal protection and equal opportunities are what founded America. Public universities cannot continue to break the law.
As I said before, Your Honor, helping minorities should not be considered a crime. Do not collaborate to make it seem like one.
All arguments have been made. After a long discussion with all 9 justices, this is the decision we came up with. In a majority decision, 5-4, written by me, Justice Paul states, a school use of affirmative action to accept more minority applicants is constitutional in some circumstances. However, the Supreme Court rules that the university use of racial quota in its admission process is unconstitutional. Therefore, any specific numbers for minorities are considered illegal under the 14th Amendment on the Equal Protection Clause. The Supreme Court is ordering the immediate admission of Mr. Bay into the university on shutting down the special admission program. Court dismissed.